welcome. April is Bowel Cancer Awareness Month, and this is a subject I feel passionately about, not just as an employment lawyer, but as someone who's had their own personal journey with cancer. About a year ago, I went to my GP with symptoms that would later be diagnosed as cancer. And in a moment of what I can only describe as surreal irony, I received that diagnosis on the very day I was delivering a legal webinar on disability discrimination to the Sheffield Law Society. That day and the months that followed were a blur of operations, recovery, and learning to navigate a new reality. But my experience and that of thousands of others underscores a vital point. A cancer diagnosis doesn't have to mean the end of a career. For me, being off work for 6 months made me realise just how much my job was a part of my identity. Returning to work was a real privilege and actually was a crucial part of my recovery. But I couldn't have done it without a supportive environment and the right adjustments. Statistics published by Bowel Cancer UK suggest that in the UK, nearly 43,000 people are diagnosed with bowel cancer each year, many of them of working age. And as employers, creating a supportive and legally compliant environment is not just good practice, it's an essential legal requirement. This video will guide employers and those advising them through the key legal duties under the Equality Act, and will focus on 3 main areas. First, the duty to make reasonable adjustments. Second, understanding and preventing discrimination arising from disability. And third, identifying and avoiding indirect discrimination. Getting this right is essential for supporting your employees and also protecting your organisation from complex and costly legal disputes. But let's begin at first principles. Under the Equality Act 2010, a person is considered to have a disability if they have a physical or mental impairment that has a substantial and long-term adverse effect on their ability to carry out normal day-to-day activities. However, Schedule 1 to the Equality Act contains specific provisions for certain conditions. Cancer is one of them. Section 6 of Schedule 1 provides that cancer, HIV infection and multiple sclerosis are each a disability. And this is a critical point. The protection begins from the very day of diagnosis and continues for as long as the person has cancer. It even extends to those who've had cancer in the past. The employee doesn't need to show that the cancer has a current substantial adverse effect on their daily life, nor do they need to personally identify as disabled to be protected. And this automatic protection is the gateway to the legal duties we're about to discuss. It means that as soon as you, the employer, know or could reasonably be expected to know that an employee or worker has cancer, your legal obligations are triggered. And equally, this is an important point for employees. It's often very difficult to contemplate discussing your diagnosis and its effects with anyone, let alone your boss. But it's critically important for you to find a safe way of doing so, because if your employer is not aware of your condition, then they can't be expected to make reasonable adjustments for you in the workplace. And this question of knowledge is often critical in any claim for a failure to make reasonable adjustments. The extent of the Equality Act's protection in cancer cases was considered in the Court of Appeal case of Curtin and Tetrasil Limited. Now, in that case, an employee had asymptomatic prostate cancer, but suffered incontinence as a side effect of the surgery to treat it. The court decided that an impairment resulting from medical treatment for cancer is still considered a consequence of the underlying condition. And what this means is that the protection extends not just to the cancer itself, but to the often debilitating side effects of the treatment required to fight it. Perhaps the most proactive and important duty an employer has is the duty to make reasonable adjustments. This isn't about giving someone with cancer an unfair advantage. It's about removing the disadvantages they face because of their condition to ensure that they can perform their job and are not put at a substantial disadvantage compared to non-disabled colleagues. So what does reasonable mean? Well, the law doesn't provide a rigid definition. It depends on the circumstances and will be assessed based on factors like how effective the adjustment will be in overcoming the disadvantage, the practicability of the change, the financial cost and the resources of your organisation, and any potential disruption to your activities. For an employee with bowel cancer, the need for adjustments can vary greatly. Treatment side effects like fatigue, pain, and unpredictable bowel habits, including the need for urgent and frequent toilet access, are common, and some people may have a stoma which requires management during the day. So let's look at some practical examples of possible reasonable adjustments for workers suffering from bowel cancer. First, flexible working. Allowing altered start and finish times can be really helpful in managing fatigue, as can travel during off-peak hours. A phased return. This in particular was vital for me. After 6 months of being away from work, returning gradually, building back up to my full hours and workload was really essential. Modified duties. Temporarily or permanently removing tasks that are particularly difficult. For example, for workers who have to undertake heavy lifting or extensive travel. Disabled toilet facilities. Providing these can greatly help employees who have a stoma, for example, both in terms of extra space and also affording them greater privacy. Managing absences. Allowing time off for medical appointments and treatment. It's also crucial to discount disability-related absences from any triggers in your sickness absence policy. And we'll touch on this later when we discuss different types of discrimination. And finally, performance targets. Adjusting targets to account for the impact of fatigue and reduced hours. As with everything, communication is key. You should have an open and sensitive conversation with the affected employee about the challenges they're facing and what you can do that might help. And in doing that, it's important not to make assumptions because what works for one person may not necessarily work for another. Now let's turn to a specific type of discrimination that's highly relevant in cancer cases. That is discrimination arising from disability, and this is covered under Section 15 of the Equality Act. This occurs when you treat a person unfavourably because of something arising in consequence of their disability, and you can't show that that treatment is a proportionate means of achieving a legitimate aim. Let's break that down. First, unfavourable treatment. This is broader than the definition of less favourable treatment in direct discrimination cases. It simply means the employee has been put at a disadvantage. Second, something arising in consequence of. This is the crucial link. The unfavourable treatment is not because of the disability itself, but for something that results from it. For example, an employee isn't dismissed because they have cancer, but because of their high level of sickness absence, which is a consequence of their cancer treatment. Other examples could include denying a promotion to an employee whose performance has dipped due to fatigue from chemotherapy or some other form of treatment, giving a formal warning for missing targets to someone who's been working reduced hours as a reasonable adjustment, or deciding not to award a bonus because a person has taken extended sick leave. The 2022 case of Willis and NatWest Group provides a stark real-world example. This was a first instance decision involving an employee diagnosed with bowel cancer who was denied a performance review, dissuaded from applying for other roles, and ultimately dismissed while recovering from surgery. The tribunal found that her dismissal was tainted with discrimination because the decisions were linked to her cancer-related absences and the perception that she would be unable to work. Now, unlike direct discrimination, an employer has a potential defence to a Section 15 claim, that is, objective justification. But they must prove that the unfavourable treatment was a proportionate means of achieving a legitimate aim, and that's a very high bar to meet. An employer would need to show that there was a real business need and that there were no less discriminatory ways to achieve it. Finally, we need to consider indirect discrimination. This is often more subtle and can be unintentional. Indirect discrimination occurs when an organisation applies a provision, criterion or practice, a PCP, in the same way to all employees, but it has the effect of putting people who share a protected characteristic like disability at a particular disadvantage compared to those who do not. A PCP can be a formal written policy or just an informal, established way of doing things. Let's consider an employee with bowel cancer. A seemingly neutral policy could have a discriminatory impact. For example, a strict attendance policy that triggers disciplinary action after a certain number of absences could disproportionately affect an employee who needs time off for treatment. A policy requiring all staff to work from the office full-time could disadvantage an employee who suffers from extreme fatigue or has unpredictable bowel issues that are more easily managed at home. Competitive promotion criteria that heavily favour employees with an unbroken record of high performance could indirectly discriminate against someone whose performance has been temporarily impacted by their treatment. And a strict policy on break times during the working day could significantly disadvantage a person with bowel cancer who requires more frequent comfort breaks. Like discrimination arising from disability, indirect discrimination can be justified if the employer can show that the PCP is a proportionate means of achieving a legitimate aim. But the first and the best course of action is always to consider if the policy is truly necessary and whether reasonable adjustments could be made to mitigate its discriminatory effect. Managing cancer in the workplace requires empathy, flexibility, and a solid understanding of an employer's legal duties. From my own experience, I can tell you that knowing you have a supportive work environment makes an enormous difference to your recovery. So let's quickly recap the key takeaways. First, recognise the protection. An employee with cancer is protected from discrimination from the day of diagnosis under the Equality Act. Second, make reasonable adjustments. Proactively discuss and implement changes to remove disadvantages. This is a legal requirement and not an optional extra. Third, avoid unfavourable treatment. Be mindful of discrimination arising from disability. Scrutinise any decision that could negatively impact an employee because of something connected to the cancer, such as absence or performance. And finally, review your policies. Examine your workplace rules and practices for any potential indirect discrimination and ensure they are justifiable and they're flexible. I was lucky. I was given a second chance. The just-in-case letters that I wrote to my children are still sealed and in a box, and I'm now back at work and I feel healthier and happier than I have in a long time. But a huge part of that is because I had a job to come back to. And by fostering a supportive culture and adhering to the law, you can give your employees that same opportunity while retaining valuable talent and protecting your organisation. Thank you for watching.